Hi, I'm Duane Coker, attorney and founding shareholder at Coker, Robb Cannon Family Lawyers. One of the issues that we've been dealing with most often since the beginning of the COVID-19 crisis is working with clients who are no longer able to pay their child support or pay the amount of child support that they were paying prior to the crisis. Many of our clients and people with whom we've consulted are in the service industry or are professional musicians, and even as late as this past week, many of them have no idea when they'll be returning to work. Lost jobs and reduced hours simply make it impossible to meet their court-ordered support obligation. There are several important points to be aware of if you are currently under an order to pay child support and you're unable to comply with the terms of that order. First, if you have lost your job or your income has significantly been reduced because of the COVID-19 crisis, it's important to file for a reduction now. Do not wait. Under the Texas Family Code, the code that the courts operate under when deciding family law matters, the court can only reduce your child support back to the date that you file and ask for the reduction and then serve that request on the other parent. This is super important. While the court might not hear your case for several months, the court does have the ability to retroactively reduce or eliminate some or all of the obligation you were under. However, if you wait several months and then file asking for a reduction, the court will not be able to relieve you of the burden of paying that accumulated back support. This can create significant financial hardships and even subject you to potential penalties. The second important point is that you do need to weigh the cost of asking for a reduction in support against the amount of support that you'll end up not being ordered to pay. In other words, if you only expect that your income will be reduced for a matter of weeks, then the cost of requesting and obtaining a reduction might actually exceed the amount of child support that you save. It ends up being a math problem. However, while this is an important consideration, we have seen clients who waited early on thinking that their loss of income would only last a week or two and are now several months into not having a job. For some we've worked with, this has resulted in thousands of dollars of unpaid child support, potential penalties from the court, almost certainly interest on the unpaid child support, and other hardships that could have been avoided by seeking a reduction as soon as the need arose. It's a tough balancing act, but an experienced family lawyer can help sort it out. Third, remember that you always have an obligation to support your children, even if you're out of work. I know everyone knows that, but sometimes, while you may need to seek a child support reduction because of the amount previously ordered by the courts just not doable, you could also continue to do everything that you can to support your children. This includes filing for unemployment, seeking government assistance, working with the other parent to reduce expenses, and so on. The court will respect the fact that you are doing what you can, and conversely, if you just stop paying support and do nothing, the court is likely to take a very dim view of those actions. The cost of a consultation with a qualified family lawyer often pales in comparison to the amount of support and associated hardships that can be incurred if you do nothing. We are consulting with potential clients on a daily basis about these issues and have attorneys ready to do a video consult, often the same day that you call, and to begin the process of seeking relief from the court as quickly as possible. Thanks for joining me today for this CRC Family Law Brief. Be sure to check out our website, cokerlegal.com, and our Facebook page for more information on Texas family law that matters to you.